Good afternoon, everyone. Good afternoon, Tony, Aminat, Ebe. Good morning, sorry. Good morning. I hope you can all hear me. Right? Can you hear me, please? Amina, if you're on the call, please indicate if you can hear me. Tony, okay. Thank you very much. I can see someone on the chat box says they can hear me. All right, so we all know my name is Hussein Mahadi, and I'm the moderator for today's session on energy industry mentorship and internship program. Today is the week 4 of the mentorship program, and the topic for today is contract, regulatory compliance, and dispute resolution in the energy industry. And with us today, we are having 4 mentors on the energy industry: Mr. Toby Amo, Mr. Ayobami Dafe Iyola, Mr. Alexander Olatunde Akolo, and finally Mr. Afolabi Ojosu. So these are our 4 mentors for today's mentorship program on energy industry, and I can see Mr. Ayobami and Mr. Toby are on the call with us. Good morning. Everyone should join me in welcoming our mentors that are on the call, and thank you very much for joining us today. So without wasting much of our time, I will be reading our mentor's profile immediately. I'll start with Mr. Toby's profile. Toby Amo is a project finance attorney at a top global law firm. He advises lenders, sponsors, and developers on developing and financing of energy and infrastructure projects. He is qualified to practice law in Nigeria and New York, USA. He obtained his LLM degree at the New York University, after which he observed a fellowship at the International Energy Agency, Paris. Thank you very much for joining us today, Mr. Toby Amo. Ayobami Dafe Iyola is our second mentor for today. He's a barrister and solicitor, compliance specialist, PhD researcher, and law author. He has about 12 years experience working in law firms, oil and gas, power, and maritime companies in Nigeria and the United Kingdom, where he gained in-depth knowledge in litigation and dispute resolution, commercial and corporate practice, corporate governance, contracting, regulatory compliance, and ISO internal audits, due diligence, and foreign investment regulation. He obtained law degree from schools in Nigeria and England, and was awarded several certificates from Ivy League schools in the United States: Yale University, contract law, University of Pennsylvania compliance program, and top-ranked school in the United Kingdom, University College London, GDPR, King's College London, the Modern Judiciary, Coventry University Business Strategy. He is a member of several organizations such as the British Law Forum, International Association of Marine and Shipping Professionals, International Compliance Association, and the Nigerian Bar Association. He has some published work with Lambert Inc., German, titled International Cooperation and Joint Ventures, Litigations that Limit Foreign Investment, on sale on Amazon and Journal of Applied Business and Economics, New York, titled company's rights to choose its nationality, among others. He is currently a consulting legal manager, Kwale Genco FZE at Sterling Exploration and Energy Production Co. Limited. Thank you very much for joining us today, Mr. Ayobami Dafe. Kindly join me in welcoming Mr. Ayobami on the chat box. Our third mentor for today is Mr. Alexander Olatunde Akolo. Alexander is a dedicated professional with demonstrated experience in regulatory compliance, government regulations, contract administration and settlements, negotiation, research, and reportage in Nigerian electricity supply industry. He recently joined Nextia Power, a subsidiary of Nextia Capital Limited, as a senior energy consultant. Prior to this role, Alexander was a regulatory affairs and government regulations manager at Nigeria's largest electricity distribution company, Ibadan Electricity Distribution Company PLC. Alexander has deep knowledge on the plethora of regulations and directives in the NESI. He has worked as a technical assistant, Bureau of Trade and Investment, and a contracts management analyst at the Embassy of Brazil and the Nigerian Bulk Electricity Trading PLC, respectively. Alexander is about to complete a Doctor of Philosophy PhD degree in Energy Studies, Renewable Energy Finance from the University of Ibadan. He holds a MSc Energy Studies degree from the University of Ibadan and a BSc Economics degree from the University of Jos. He has attended several energy conferences within and outside Nigeria. He is a member of Nigerian Association of Energy Economics, NAEE, Global Association of Risk Professional, GARP, Society of Petroleum Engineers, SPA, and Energy Institute. Thank you very much for joining us today, Mr. Alexander Akolo. And finally, our last mentor for today is Mr. Folabi Ojosu, Manager Legal and Corporate Service at Smile Communication Nigeria Limited, has particular expertise in telecommunications and energy project development, regulation, and policy. He has advised governments, operators, and investors on a wide range of transactions involving the development of on and off-grid power projects, metering service, offshore oil and gas exploration, production facility, utilities, and infrastructure. Electricity market expert, Mr. Folabi is a former legal advisor to the Nigerian Association of Energy Economics and doctoral candidate at the Center for Petroleum and Energy Economics and Law of the University of Ibadan. Prior to joining Smile, Mr. Folabi has held contract and corporate advisory role at Ikeja Electricity PLC, career partner, the Nigerian Electricity Regulatory Commission, and the Enugu State Ministry of Justice. He is an avid author and has published in acclaimed academics, legal, and business publications. Thank you very much for joining us also, Mr. Afolabi. Those are our mentors for today. Thank you everyone that welcomed our mentors on the chat box. We encourage everyone to put on their videos, especially our mentees on the call. I'll be calling on, okay, I can see Mr. Ayobami, Mr. Alexander Akolo, and Mr. Toby Amo on the call. So I'll be calling on Mr. Toby Amo to start the mentorship program today and give us an overview and introduction of the topic, contracts, regulatory compliance, and dispute resolution in the energy industry. Thank you very much.
Hi, thank you for the opportunity to be in this session today, and hi to everyone. I think that I'm looking forward to seeing the presentations by the various groups, but I think that the when it comes to energy or when it comes to power projects, I think that regulatory compliance is at the very key of the success of any project. Because if you're going to finance a project, and I'm talking from a financing perspective because that's what I do, I think that what lenders or investors will want to know is if the project can be completed. And if there's a risk that some permits have not been gotten or there's no compliance with certain regulations or laws, then lenders or investors will be less likely to invest in the project. So it's very key to make sure that all the regulatory compliance issues with the project are dealt with. And I think in relation to that is also dispute resolutions. You also want to reduce the risk that disputes might delay the project, or even if there might be a delay, you want to make sure that there are adequate protections for all the parties in terms of the dispute. So when you're dealing with like the construction contract, you want to make sure that the dispute resolutions are well done, so that if there's any dispute in terms of the construction phase or in terms of the standard of construction, that those disputes are able to be resolved immediately or adequately, and so that there's no delay in the project. So having said that, I think that the topic for today is very key and is very crucial for just energy projects generally. And I think that if anyone who is interested in exploring energy just as a law career, I think that those are areas that they should be looking to increase their skills. Thank you.
All right, thank you very much, Mr. Falabi. Mr. Toby, I'm sorry for the brief overview of the topic. I'll be calling on Mr. Ayobami to also give us his introduction on the topic.
Good
Mr.
morning, all.
Ayobami.
Yes,
Good
please, can you
morning,
hear
sir.
me? Good morning.
Yes, we can hear you, sir. Good morning.
Yes, perfect. Yeah, and here we are again another week, and there's a lot to say about contracting and dispute resolution, and a lot to also say about regulatory compliance, and those three things are quite key when it comes to energy. Mr. Toby has said a lot, and I'll just run on the back of that since I have quite limited time. And contracting, I mean, depends how good your project would actually go, because there are various terms and conditions you have to factor while working with a project team, the finance team, the commercial team, the insurance team, and so it's as a contract person, you have to most likely working hand in hand with all of them, try to understand what they're trying to tell you, and you see how you can factor it into your contract. So basically, off my head, I would say that you should pay special attention to the liability and insurance clause, the taxes most especially, because taxes has been known to make or mar a project, especially when you have a pretty small profit margin, and like something I've learned over the last decade or so in contracting is that when it comes to energy and power and maritime also, is that especially when you have a foreign entity coming to work in your jurisdiction, maybe Nigeria, for example, most people tend to just say, oh, any tax out of Nigeria goes to the foreign entity, and taxes in Nigeria comes to the Nigerian entity, and they fail to know that sometimes the foreign entity might be liable to pay taxes in Nigeria depending on the state. They might be liable for personal income tax of their employees if they have boots on ground in Nigeria, and they may also fail to understand that also they might be liable to complain income tax depending on duration in Nigeria. So technically, when you say all taxes in Nigeria, so that means you're most likely taking the liability of the foreign entity, which you might not factor into your project. And guess what? The taxman might not, the foreign entity might not be registered in Nigeria as a tax entity, and the taxman doesn't definitely know them, so they won't go after them, and most likely they'll just come after you because you are supposed to be the one, representing them in the country since you're bringing them in. So there are also things like deferred correctional warranty period, guarantee, and everything, and of course, moving to the compliance. There's always the compliance angle of it. The foreign entity might have limited knowledge, but good foreign entities will always place in mind that they will take tax and finance advice from any of these big four or auditing or financial advisory firms. They always do that to be on the safe side. But usually, you as a lawyer also need to have know about all of this. So it goes beyond you being a lawyer. There, when you're into contract management, you have to know a bit about every single thing. So that you can be up to date and ask the seemingly stupid questions when you're talking to the insurance experts, for example. As little as deductibles in insurance. Deductibles are basically means that if you insure a vessel equipment for like $1 million, if anything happens, you might give $950,000, and they keep $50,000. They call it deductible for expenses and other things. The assessor could go in to check out what happened and claims and everything. So that $50,000 might just be that you think it's insured at 1 million and there's 50,000 difference. So who bears that $50,000? It's as simple as that. So you must keep abreast. You must virtually sit on the head of those experts so that whatever you want is really factored into the contract. Now, back to regulatory, the oil and gas industry, we have the PIA coming with pretty new regulations, and the former DPR is now the Nigerian upstream, and so their permits, their licenses, and you have to keep the tab on. There are good softwares nowadays that helps you to tell you when a license is about to expire and everything. And if you are doing energy and it's offshore, that the maritime most likely comes into it. And Nigerian Maritime Institution Safety Agency in the master has a whole long list of licenses you have to have. GPR also has offshore rig permits you have to get. So as a lawyer, you have to, especially if you're in the compliance line, you have to keep a tab on virtually every single thing. So it's pretty large. I was once on the Chevron Agbami project, and I had to keep tabs on a lot of documents. Sometimes I have when I do more contracting now and less of compliance, but sometimes I'll have as much as 100 licenses and certificates that might expire at any time. So software has helped in keeping the tab of 90 days prompting when to start renewing, and things like that. So because honestly, there are fines and they involved. So under the PIA, for example, they are trying to introduce we spoke about flaring, I think a couple of weeks ago, and climate change. They're about trying to introduce taxes for hydrocarbon taxes, then flaring also, penalties for it and things like that, And so it's like that. Then when it comes to dispute resolution, it's most very important that you understand how you want to couch it. Now, you don't give room for forum shopping, for example. Forum shopping is it's the way you go to the market and shop for something that, this is what I want. That's how you go about shopping for courts or dispute resolution mechanisms that would most likely favor you. So if you don't have it tightly agreed in the agreement, it gives room for, if I think I will get a good judgment in Abuja, I go for it. And you might want to go to Lagos, and it becomes a whole conflict of laws and things like that. So it means that you have to tie it neatly and tie it very well. It's important that if you're going to be Nigerian law, especially the petroleum and energy, try to frown on having agreements, especially when you're Nigerians, or having this resolution mechanism abroad, but it's been done daily in contracting in Nigeria. Yeah, because I know in NCDMB will always tell you that you shouldn't contract a law firm outside Nigeria. Yes, they always tell you that in their annual audits. Yeah, and if you have to if you have to do that, you have to go through a Nigerian firm to the foreign firm, basically. Yeah. So this, and we have to, even there's a local content for in the power sector also. There's a law on that, which means that they're trying to promote local use of investors, local equipment, and local personnel as much as possible, just like we have in the Cabotage Act, which tries to encourage Nigerians to go into more in the maritime and oil and gas and power sector. So these are regulations that you have to keep a tab on. That when you're dealing with foreign investors, which most of the time we need foreign investors to come into, we have to keep all those tabs on all those regulations, and they help us. This resolution, you have to keep it tight, neat, know what you want. If you're going for a law of England, there's nothing like law of England and Wales anymore, actually. There's nothing like law of United Kingdom, because United Kingdom talks about Scotland, talks about Wales, talks about England. So I see a lot of England and Wales, but since 2015, the Welsh law has it like, they have it like a separate law for people of Wales. So if you write England and Wales, then that's a foreign shopping way, in the sense that they can say that if they think that the Welsh law would favor them more, they will go for it against the English law and everything. So try and keep it neat, tight, the mechanisms clear, so that all parties will know that when they do this resolution, it can easily be resolved. Thank you. Yeah.
Thank you very much, Mr. Ayobami, for the comprehensive overview and introduction on the topic. I will be calling on our third mentor. I can see that Mr. Afolabi is also on the call. Good morning, Mr. Afolabi, and welcome to the call today.
Good morning.
Thank you very much, sir. So I'm calling on Mr. Alexander, if he's still on the call with us.
Hello, guys. Good morning.
Good morning, sir.
Thank you for having me. Yeah, my name is Alex. I will be talking about this topic, and I will limit my scope to the Nigerian part, to the power sector, because that's where I have the bulk of my experience. When this topic was sent to me, right, I just felt the energy sector is very broad, and I don't know, I'll just appeal to the organizers of this program to find a way, if you can, unbundle it. Maybe oil and gas should be separate, and power should be separate. Well, having said that, on the contracting side, on the power sector, we need contracts. Contract is what is the bedrock, of the power sector. On the generation side, we have what we call power purchase agreements. On the distribution side, we have what we call vesting contracts. And these agreements dictate or set out the laws and the rules, including regulatory compliance, as well as dispute resolution. So these three components are intertwined, they are interrelated. In the contract, it says how many, as I said, please don't forget, I'll be focusing on the power sector. The contract dictates how many kilowatts or megawatts of energy will be traded, how they'll be paid for, when payments will be made, the kind of laws you follow. Also, it also dictates the standards and how disputes are going to be resolved. Disputes are unavoidable. There are always issues in terms of billing, in terms of quantity, and all that. So that's where dispute resolution comes in. And in the power sector, one thing I noticed is that the players, especially the regulator, does not like going to court. So in most of the agreements, you see a part saying that when there are disputes that cannot be resolved, the parties are going to appoint an arbitrator, right? So arbitration is one of the things that is one of the mechanisms or one of the tools for dispute resolution in the power sector. Also, talking about regulatory compliance, as we know, the regulator of the power sector, Nigerian Electricity and Regulatory Commission, NERC, set out lots of orders, directives, regulations. Examples are the meter set provider, and NMP, that is Nigerian Mass Metering Program 2021, the mini grid regulations 2016, the eligible customer regulation 2017, and all that. There are lots of regulations. So there needs to be somebody or a group of people that ensure regulatory compliance, and the benefits of complying to regulatory compliance cannot be overemphasized. One of the license Can you hear me?
Yes, I can hear you now.
Oh, sorry about that. Oh, sorry. So I was just saying that for those that are conversant with what's going on in Nigeria right now, NEC is considering canceling the license of Kaduna Disco because they've not complied with NEC's directives with respect to their minimum remittance obligations. They're owing the market a huge sum of money. So this is just to just show you the interconnection or the interlink between regulatory compliance, contract, and dispute resolution in the power sector. I look forward to listening to further engagements. Thank you.
And thank you very much, Mr. Alex. I'll be giving up to the last mentor on the call, Mr. Afolabi Ojosu, to give us his own overview before we move on to the mentee's presentation for today.
Okay. My friend and brother, my best friend and brother, Alex, has actually said a lot. I've looked at the presentation and I think it's skewed towards oil and gas. A whole lot of people have said energy. So what I've heard is the presentation should be an energy presentation, but I've seen mostly oil and gas. So I've seen JOAs from the oil and gas perspective. I've not seen JOAs in terms of renewable energy, in terms of power distribution. So I think we need to set the tone for what energy is, to define that energy is not just oil and gas. Energy is oil, gas, and power, all right, and associated sources of energy. I did my master's thesis in nuclear power, all right, and I can tell you we have JOAs in nuclear power plant operations. All right, so I believe between Ayobami and Alex, they've covered the field. If there's anything I need to come into, I would at the end of the presentation. Thank you.
Okay, thank you very much, Mr. Afolabi. I'll be calling on our mentees to give their presentation now. We have two presenters, presenter one and presenter two. Presenter one, kindly unmute yourself and share your screen and start your presentation. Kindly note that you have 10 minutes for your presentation. We can see your screen, but we can't hear you talking. Angel.
Hello, good morning.
Yeah, good morning.
Okay. All right, good morning. So you're seeing the screen, right?
Yes, you can see your screen.
All right, okay. Thank God. All right. So I'm presenting on the JOA. So I'm just going to give a brief. I'm still audible, right? All right. Okay, I'm going to give a brief overview on the joint operating agreement, specifically the oil and gas. Yeah. Okay. So the joint operating agreement in the oil and gas industry, like is an underlying contractual framework of a joint venture. What we mean by joint venture is two parties come together and they agree, they make an agreement. But in a joint venture, it's not like partnership where both parties necessarily have share the same profit. So the joint operating agreement is a contract where two or more parties come, like they agree to undertake a task to explore hydrocarbons. And then in the agreement, the parties are classified as the operators and the non-operators. Okay. Okay, they are classified as the operators and non-operators. So the operator is the one who is responsible for the day-to-day management. Like the operator is the person in charge of the operation of the field. And the operator has full control over the operations. And it's to be noted that the operator doesn't necessarily receive remuneration. And the duty of the operator is to carefully plan the activities, like in order to increase the profitability of the operation. But the operator is usually not liable for any loss of production or revenue, except in cases where like it can be proved that the operator on his own part was negligent or omitted to do the right act. And on the side of the non-operator is the party that provides for the money. I don't know, am I still audible? Okay, I'm still audible. Okay, the non-operator is the party that provides the money for the agreement. And then it's to also be noted that the voting rights of the operators and the non-operators is, I think, is how they specify it in their agreements. So I'm going to share a brief history on how joint JOA, that is the Joint Operating Agreement, came into Nigeria. So it was introduced, like the concept of joint venture was introduced where the Nigerian National Oil Corporation partnered with IOCs. Yeah, yes, with the IOCs. And the joint operating agreement is just basically is outlining the rights, obligations, and responsibilities of the parties involved. And then the framework, like the legal framework in Nigeria that provides for the joint operating agreement in the oil and gas sector is the Petroleum Act of 1961. Like the Petroleum Act provides the laws for the joint operating agreement, and it also provides for the right and obligation for both parties that will be involved in the exploration and production activities. Though, like over time, Nigeria has made amendment to the legal framework, like so as to enhance the country's share of revenue from the oil production. And then in the joint agreement, like the joint operating agreement, it's like the joint operating agreements usually have what like is consists of or entails the duration of the agreement, parties to the agreement, scope, the liabilities, the transfer of interest, the hydro allocation, and so on. Though concluding, in like the significance of joint operating agreement in the oil and gas industry in Nigeria is that like it enables parties to come and collaborate on exploration and production, which will be involved in the development of hydrocarbon resources. And then the agreements are usually formed between different parties, which could include international oil companies with Nigerian Oil Corporation. So that is for my presentation. Thank you.
All right, thank you very much, Angel, for your presentation. We await comments from our mentors and also any correction on your presentation. I'm calling on the second presenter to quickly give us his own presentation. Presenter 2.
Hello?
Yes, we can hear you.
Okay, I'm just curious. The first presentation was on what exactly? On joint ventureship and agreement, or I mean?
Yes, sir.
Okay.
I don't know. Can you guys hear me?
Yes, we can hear you.
All right. All right. So, good morning, everybody. I'll be making my presentation on the regulatory compliance in the energy sector. Now, the energy industry is a crucial sector in many modern economies due to the growing demand, in technological innovations, high competition, and others. Energy companies will need to keep up with these changes in order to stay ahead. And it is imperative because of that to ensure that they are under some regulations. Now, these regulations, they vary. They go from the national to the international, both at the regional levels. And some of the most common ISO standards for energy across the globe. Now, an ISO is an independent system operator. It's an independent system operator. It is an independent and federally regulated entity that coordinates regional transmission to ensure non-discriminatory access to electric grid and a reliable electricity system. Now, this is an internationally recognized entity, and some of its standards in the globe includes the ISO 9001. And then the ISO 9001 is in a bid to ensure that employers work efficiently using practical processes to deliver top quality products. ISO 911 becomes very, very handy. It is the most used quality management system standard in the world. The second one is the ISO 14001. The ISO 14001 is the environmental management system standard, and it is a system that gives you a kind of control over the organization's environmental aspects to reduce impact and ensure legal compliance. And then the third one is the ISO 5001. The ISO 5001 is international standard for energy management systems. I don't know, can you guys still hear me?
Yes, we can hear you.
All right, all right. So certification to this standard is a commitment to improving energy management in the facility. Then the advantage of this certification is that if you hold the certification of an ISO 14001, achieving ISO 5001 will be easier to accomplish, since the framework of both the ISO 14001 and that of 50001, they are similar. Then the fourth one is the ISO 45001. The ISO 54001 is the standard for occupational health and safety. This is with regards to safety in the workplace and other places. Then the ISO 27001, it provides the framework for information security and management systems. And the PAS 2060. The PAS 2060. Now the PAS is publicly available specification. It is an internationally recognized specification or standard for carbon neutrality. It defines the good practice for a product, service, or process. And this PAS 260, it has 4 stages for achieving carbon neutrality, because I mentioned earlier that it's a standard for carbon neutrality. The first stages is the measuring, then reducing, offsetting, and then documenting. Now, the ISO 37001. The ISO 37001 is a standard for anti-bribery management systems. Yeah, it will help to prevent bribery from occurring in the companies. Now, let's go to the power sector, Nigerian power sector regulatory bodies. The first power sector regulatory body that we'll be looking at is the Nigerian Electricity Regulatory Commission. Now, the Nigerian Electricity Regulatory Commission, the NEC, is an independent regulatory agency which was inaugurated on 31st October 2005 as provided in the Electric Power Reform Act of 2005. Yeah, it plays an important role in the power sector. Yeah, in addition to the usual of protecting consumers through the development of customer service standards and fair pricing rules, and provide effective dispute resolution mechanisms, NEC is also responsible for tariff regulation, fair pricing, and all that. And then, by virtue of Section 96 of the NEC Act, it is mandated to make regulations prescribing all matters which are required or necessary for operational convenience. And I remember one of our mentors mentioned on some of the regulations of the NEC, and some of those regulations include the Consumer Protection Regulation of 2023, the NEC Distribution Usage Fee 2 of 2021, and all that. And then it also engages in transmission, distribution, and trading, monitoring activities of the electricity market, and overseeing any amendments to the market. So whenever there are amendments to the power market, the electricity market, the NEC sees to that. The second agency is the Federal Ministry of Power. The Federal Ministry of Power is tasked with initiating, formulating, coordinating, and implementing board policies and programs promoting the development of electricity generation from all sources of energy in Nigeria. And then the Energy Commission of Nigeria, the ECN. The ECN plays a very important role. The ECN was established by Act number 62 of 1979, which was amended by Act number 19 of 1989. The ECN is charged with responsibility for the strategic planning and coordination of national policies in the field of energy in all its ramifications. Now, the method of achieving this, this mandate of the ECN, is through inquiring into and advising the government of the Federation or the states on adequate funding of the energy sector, including research and other things. Now, the ECN also serves as a center for gathering and disseminating information relating to national policy in the field of energy. Now, let's look at the energy sector challenges to regulatory compliance. Now, the energy sector battles with a lot of challenges, like the bad economic state. The bad economic state of the country is a kind of mitigating factor to energy challenge to regulatory compliance in Nigeria. The fluctuating economic state in the country is really adversely affecting regulatory compliance, and also geopolitical and weather conditions. Geopolitics and weather conditions, it's also affecting regulatory compliance. These are also capable of limiting the energy industries in regulatory compliance. In addition, organizations in the industry face more challenges regarding security. Security is really affecting them, and also data privacy, risk assessment in the energy sector, and experience additional pressures due to a large number of standards and regulations. And that's all for my presentation. Thank you for listening.
Thank you very much, Joel, for the presentation on behalf of your group, and also our first presenter, Angel. Thank you very much. Quickly, before we take comments from our mentor, we encourage everyone to put on their videos. I'll be taking a quick screenshots of our meeting today. So just for 30 seconds, put on your videos while I take the screenshots. Thank you very much. Okay, thank you very much. I've taken some screenshots. So one of our mentor has left the call. He sent his apologies, Mr. Amo, Toby Amo. So I'll be taking the first comments from Mr. Alexander Akolo on the both presenters' presentation.
Okay, thank you. On the first presentation, I was struggling to understand what exactly she was talking about. I saw joint venture agreement. She said a lot and all that. There were no examples of, I don't know if I missed that, but there were no examples of JVs that have been entered into in the country among the IUCs, that is the international oil companies, or the national oil companies. I mean, I was expecting to see one or two examples. These are the JVs that were signed between these countries, between these companies and all that. I didn't see that. On the second presentation, I liked it, especially the part where he talked about the Nigerian power sector. And I just want to point out to him that when you say regulatory bodies, there's only one regulatory body in Nigeria for Nigeria's power sector. Is only one, and that is NEC. And the others are, as you rightly said, Ministry of Power gives policy direction, Energy Commission coordinates the policies and all that. Those were very, very aptly put, and it shows that you did a lot of research. You put a lot of work into your presentation. I liked it. Those are my comments. Thank you very much.
Thank you very much, Mr. Alex. I don't know, Mr. Ayobami also have contributions to the presentation or any comments. So you're muted.
Yes, I guess you can hear me now. Yeah, even though I got the slides pretty late last night, I think I'm just trying to have a good look at it now. Looks just like I think Mr. Folabi spoke earlier. It was good to have the oil and gas and power maybe in different silos. I think, I don't know. Yeah, I mean, yeah, I'm lucky to have oil and gas and power experience. I mean, I know Mr. Alexandra and I feel like most likely have more experience in power than I do because I'm just a couple of years and most of my career was in oil and gas. Yes, so pretty well good. I will always prefer, like I think I told the class 2 weeks ago. I don't know if it's the same class. I always prefer if there's referencing. Yes, there's no yes, referencing. Then also, as much as possible, put in your own originality in also. Make proposals, criticize it, and basically that's what a research work is supposed to have. Who you're quoting, but referencing should not be the whole slides, but at least put in your original thoughts. Also criticize, think where it can be better, and propose things basically. Yes, on the JOA, I mean, it's Alexandra said pretty good. Yes, examples are more important. We have a lot of them in Nigeria, and then the PTC, has quite a number of, Chevron and the government, Chevron and Farm, Sterling and NPDC. There are a lot of JOAs around, and these are things you may want to have a look at, and it do you much knowledge. On the regulatory side, you need to. I didn't see any mention of the PIA. And the PIA is bringing out new agencies. And the NUPLC, the Downstream Regulatory Commission, and even on the power side, there are lots of laws under the power side, talking about the NEC regulations, the mini grid 2016, the MAP regulation 2018. There are quite a number of regulations also, so I expected to see more of that in the slide. Yeah, I was happy to see the ISO guidelines. I happened to be ISO auditor for the last 4 or 5 years in 9001, 5001, and 14001. So it's pretty good. It works more, I think, with the oil and gas industry. So yes, I know that it was a tall order marrying the oil and gas and the power together, and sometimes you lay more emphasis on one and the other. So that's why I said that energy as a whole, maybe if it can just be in 2 different segments, I think we might have more detailed presentation, and also you can learn more in details than us trying to crisscross among the 2. Fairly well, it's a good presentation. Of course, it could be better, and I think the fact that we're here is to try and make it better for you guys. So yeah, so thank you.
Yeah, Hussein.
Thank you very much. Yes, sir.
I'm sorry, please.
Yes, sir.
Apologies to everyone listening. I just want to add, right? Going forward for the mentees, for this kind of work, right? There are 3 broad topics. Why don't you just break them down? The contract. You think contract for the power sector. You talk about contract. You talk about dispute resolution for the power sector. You break it down. So you guys just jumbled everything together. So most of the parts were left out. The guy that talked on energy, on power sector, just talked more about regulatory compliance, just 1 or 2 things about regulatory compliance, but there was nothing on dispute resolution, totally nothing on that, right? There was nothing about contract. So you can't, I'm just saying this so that to prepare you guys are in school, and you're going to professional life. So you need to unbundle these things so that there'll be clarity, even if it's 1 slide per topic, because there are 3 major topics here, and they were not properly dealt with. Thank you. Apologies for taking time.
Thank you very much, sir. I think regarding that, I think we have a 3rd presenter on dispute resolution. Is the 3rd presenter on the call?
No, she's not.
Okay, that's the reason for the omission. But I thought someone said they will be stepping in for her. I think it's Emmanuel. So we can just take that presentation before we take the comments from Mr. Afolabi. If you are ready, Mr. Emmanuel, you can.
All right, sir. Good morning, everyone. All right,
Yeah, good morning.
I'll go on with the presentation even as I try to share my screen. Talking about dispute resolution in energy industry. We all know that dispute is something that as man interact with another, dispute involves another. And the energy industry is not left out from this. There are so many areas through which disputes can arise. It can come from even the contract itself. Non-performance of contract can lead to dispute among parties. Non-performance can be total failure to perform a contract or half performance and all that. Then there can be also other issues, maybe wherein a party entered into a contract and the person was through misrepresentation and all that, the person can also seek redress. And also disputes can also arise from regulatory compliance, and that's what this will also have to do with licensing and all that. It also have to do with licensing and all that. Disputes also can arise from operational activities. Let me say, for instance, maybe a business venture undertaking, let's say, for instance, in the oil and gas industry, undertaking exploration activities and that it does not comply with the regulations, just like my co-presenter have earlier mentioned, the one that presented on regulatory compliance. Someone can also sue or take up the matter to redress that issue. Issue can also come up under regulatory compliance. I mentioned about licensing, maybe
100,000 naira, and you had to pay only 10 naira per day, and you had an entire year to pay up that.
I'm hearing a voice on the background. Is it coming from my side? Am I audible to everyone, please?
Yes, you are audible.
Yes, you are.
All right. So if a business do not have license to operate, or the license has expired, such is an offense and can be redressed. Also, our mentor mentioned something about tariff regulation and fair pricing and all that. Yeah, these are also areas through which disputes can also arise from. Then, moving on to ways of redressing disputes. Generally speaking, in law, there are two broad ways of redressing disputes. One is through litigation, that is going to court, suing the defaulting party to court. And two is alternative dispute resolution or non-litigation, litigatory process. Litigation, going to court, it has advantages and it has disadvantages. One of the advantages there is that already the court is already there, the laws also there, so the system is already provided, so things we just have to run through. But there are so many factors that bedevils this very court system, in which most business people don't usually take litigation to resolve their dispute. Amongst them can include the time consuming we always experience in litigation. The cost is also there. The technicalities involved in court, in the regular court, are also there. And another matter also is the issue of confidentiality. The courtroom is a public place, and when parties are in dispute, there are a lot of things that goes on. So many evidences can be called upon, can be called in and admitted. And most at times, this can be official trade secrets and other documents that might be so much important to a business and they need to keep it confidential. But because of the dispute, they may be forced to make it public in the court. Before I move to alternative dispute resolution, I also want to say that there are potential parties to dispute in the energy industry. Like we have it in this slide, it can cut across businesses, organizations, companies, state parties, investors, and even a member of the general public, like for instance, a member of the general public through public interest litigation. It can take up a business venture, if he or herself sees that the business by the operation they do not go in line with regulations, and such activities are occasion harm. It does not necessarily mean that the person that will be suing on behalf of the general public has suffered a harm directly. We also know that, most especially, like for instance, in Nigeria, public interest litigation was not so much welcomed in the time past, wherein the court calls people names that comes under this kind of litigation. They call them busybodies and medicine and all that. But the times have changed even in the labor industry. Such are being welcomed. The court welcomes public interest litigation. Now, moving ahead to talking about resolving energy dispute through alternative dispute resolution, ADR. This involves mechanisms, other ways of resolving this dispute, other than going to the regular court, other ways. There are advantages to this resolving dispute through ADR, and in this context, energy dispute. Part of the advantages includes, among others, party autonomy. This means that the party has, to a large extent, they controls the proceedings. If it is, let's take for instance, if it is arbitration, they have a level of control over the arbitral proceedings. It can include choosing of arbitrators, choosing the law to guide them to be used, choosing ways to admit evidence and all that. So there is party autonomy, and there is access to a neutral forum. There is flexibility. The technicalities associated with the regular court is not so much there with arbitration. With ADR, things are flexible. Yes, things are flexible. For instance, such technicalities can be less in the regular court. Admitting evidence. Most of the time, someone can have evidence that is very, very crucial to supporting his or her case. But if the person do not tender this very evidence in accordance with the procedures already provided by the law, such evidence might be rejected, or even when admitted, so the weight attached to such evidence might be very little. So, but these such technicalities are not there. There is flexibility with time and all that. The most important thing also, there's the issue of confidentiality. Arbitration, ADR processes is kept secret. It's kept secret. So the party, business, transactions, and all that are not exposed to the general public to know and how. Most especially, lastly, also, the business relationship is being preserved. Litigation threatens business relationship. If a party is taking another to a court, already enmity is already created, and most, especially in most cases, if not in all cases, that enmity continues even at the end of the litigation. But in ADR mechanisms, arbitration and all that, there is it is somewhat friendly. There's a friendly atmosphere that promotes and preserve business relationship, in which even at the end of the proceedings, the parties can still engage in other business transactions. Under we have different mechanisms in resolving disputes. Under using the ADR, we have negotiation, mediation, conciliation, arbitration, expert determination, neutral evaluation, fact finding, and minute trial, and all that. So for arbitration proceedings, let's take for instance for arbitration proceedings. For arbitration proceedings can actually be ad hoc or institutional based. It is ad hoc wherein the parties on their own chooses 1, 2, or 3 persons to arbitrate on their matters. And it is institutional when they choose an organization that bases on arbitration proceedings. We have given an example of such. We have, like for instance, we have a World Intellectual Property Organization Alternative Dispute Resolution Center. We have International Center for Settlement of Investment Dispute, IEC. We have London Court of International Arbitration and all that. So also arbitration proceedings can also be domestic and it can also be international. It is domestic wherein upon it involves parties to the parties to that dispute are from one state party. Also is something domestic. So, but for international, international arbitration, this involves parties from different state boundaries, or it involves a party from the state or the subject matter of the contract and the dispute is something of international concern. So these are the things that can make an arbitration to be international proceedings. All right. So, okay. Lastly, arbitration processes are not totally free from the court system, as the latter is in need of the former at certain stages. For instance, even though arbitration involves settling a dispute outside court by choosing an arbitral panel, there are some things that the arbitral panel must involve the court in doing. For instance, if a party is not willing to arbitrate, the other party can seek the relief of the court to compel such party to arbitrate. And we also have a case of it can also be if the parties have not chosen people to arbitrate, and maybe it was an ad hoc arbitration. So the court can also come in at that point, and the court can actually choose arbitrators for them. And also, where the courts are also needed, are also enforcement of arbitrary awards. Yes, arbitration. What makes arbitration India mechanisms is that of award. At the end, they have judgment called award, and these awards can be enforced. But the arbitral panels on their own, they lack the power. Most of the times, they lack the power to enforce these awards. So they will need the court, the regular court, to enforce this award, most especially when the party that the award is against is not coming for to perform the responsibilities stated in the award. So the court can be involved to enforce the award. These are the few things I have under dispute resolution in the energy industry. Thanks so much.
Thank you very much, Emmanuel, for that in-depth presentation on behalf of your group. I learned that you stepped in as a backup presenter, and thank you very much. I'll be giving the floor to Mr. Afolabi to give us the final comments on our mentee's presentation before we move on to question and answer session.
All right. Good afternoon, everybody. Once again, I've had the pleasure of listening to all the presentations, and yes, apart from my initial comment in the oil and gas space, Alex has also talked about the power space and how it relates to NEC and tariff settings. One of the things I want to mention is, for the first presentation on contracts, is that in the power sector, contracting goes beyond JVs. So you have power purchase agreements, you have distribution agreements, you have market operation agreements, like Alexander mentioned, and each of these agreements have their own peculiarities, their own requirements, and how they operate. The Nigerian power sector is basically law and economics. I'm a lawyer, Alex is an economics, but Alex has experience in law, I have experience in economics. So it's cross-functional. And when you look at agreements and the way they operate in the Nigerian power sector, everything in the power sector is driven by agreements, from bilateral contracts to TCN delivering power to the discos. So the discos delivering power to your house. Yes, there's a form, Alex, is it form 74 of 76? I know that's the contract between the customer and the disco.
74.
74, yes, 74. So there's a contract between the Nigerian customer and every disco called the Form 74, in which the disco uses to deliver power to people's houses. So everything in the Nigerian power sector is governed by contracts. In the oil and gas contracts, yes, also governed by contract, how many scope of gas you are taking, take or pay, timelines, especially when it has to do with delivering power, delivering gas to a customer. So those are the GSAs, gas supply agreements. So I think participants should not just limit themselves to only JVs or operating agreements for oil wells alone. There are different type of agreements, and you can look at it. You might want to look for Oil and Gas Law by Mrs. Yinka Omoregbe, Professor Yinka Omoregbe. She's a very good friend. She's former Attorney General of Edo State, former Secretary to the NMPC, former Special Advisor to the President, currently President of the NEE. So you might want to look at that book, Oil and Gas Contracts in Nigeria. Yes, by Professor Yinka Omoregbe. You might also look at Why We Have No Energy in Nigeria. It's also one of our books. They are both published by the University of Ibadan. You might want to look at that in terms of oil and gas contracts and the history of oil and gas contracting in Nigeria. And then you want to look at that vis-a-vis the Petroleum Industry Act, as Mayobami rightly mentioned. The PIA is robust, from sectorizing the upstream, downstream, midstream, and making sure it appoints regulators over those areas of the industry. Also looking at gas transportation agreements. Alexander is an expert in natural gas vehicles and agreements that has to do with gas. Alex is a very, very good expert on it. So after this, you might want to contact him. Everything gas, everything renewable. He has quite a lot of experience in that. Switching to the regulatory part, I have had the pleasure of working in the Nigerian Electricity Regulatory Commission for a while. And the regulator is an omnibus regulator, regulating every facet of the Nigerian power industry, from transmission to generation to distribution. There are various laws and regulations governing the sector. So yes, everybody would say the Electric Power Sector Reform Act, but then there are recent amendments to the Constitution that begins to form part of the Electric Power Sector Reform Act. You have individual states law like the Lagos State Electric Power Sector Reform Law of 2018. I also helped put that law in position. You have the Ondo State Electric Power Sector Reform Law. And then you have various states coming up with their various power sector reform laws, in making sure that power is generated in their states. So you might also want to look that up. The power sector is changing, as you know it. Alex said you have the regulator looking at withdrawing licenses from discos, In the same vein, you also have the regulator telling discos to activate bilateral contracts, with gencos to supply power to Nigerians. So there's a whole lot to look at that. For power sector arbitration, yes, a lot of people will say one arbitrator, and there's always an arbitration clause built into all these agreements. So following various arbitration clauses that we have, I like to arbitrate at London. A lot of people like to arbitrate in Lagos. Other people like to arbitrate in Hong Kong. But you must make sure that you understand the rules under which you're arbitrating, you understand the language under which you're arbitrating, and you have the option of selecting these rules and the language and the place of arbitration while drafting the agreement. Like Ayobami said, you must be very specific in the laws you are selecting, because the other party might look at which laws are beneficial to them. For instance, if you say laws of England and Wales, like he said, if the laws of Wales are significantly beneficial to me, I'm going to take them. So we need to look at those instances. Finally, the person that spoke on compliance, somebody mentioned ISO, and the person said something. So ISO is International Standards Organization. So they are not standards which are a must for operators. They are standards in which operators adhere to in their operations. So I think I need to correct that. They are standards operators adhere to, and then they are certified. Either you are certified by the SGS, and then you are given the certification mark. In Nigeria, I think only Ikeja Electric has ISO certification, and they have 3 ISO certification, 15,001, 9,001. So they have ISO certifications for health and safety, quality management system, and one other ISO. So because I am an ISO internal auditor, so I can tell you these standards are quite peculiar. But then as operating standards, they show the entire world that you have achieved a set of operational policies and principles which are global enough for you to operate by. Anybody saying that you have an ISO certification will know that your company is standard. So I think you might want to look at that and the methods of obtaining ISO certification. In relation to compliance, all right? In relation to compliance for the oil and gas industry, you have the Nigerian Upstream Regulatory Commission, the Nigerian Downstream Regulatory Commissions. So you need to know which area of which segment of the market you're operating in, and you need to know which regulator is regulating that segment of the market. All right. By doing that, you will know where you fall onto. And finally, like I said, we need to split power into their various components, or we need to split energy into its various components, rather. So we need to split energy, oil, gas, power, and renewables. So renewables. So renewables, fuel cell vehicles, solar power, we need to split them appropriately. I believe the course is broad, and we might not have enough time to go through all the motions. But this little that we have here, I believe we can build on it over time and get everybody appropriately into which field of energy they want to go to. Thank you very much, everybody. Hussein, are you still there?
Yes, your voice was cracking, so I didn't know if you've ended.
Oh, okay. Sorry.
Yeah. Okay, thank
Sorry.
you very much,
So,
sir. And
yeah.
thank you very much for the insights and the corrections and also the contributions. And also, Mr. Alexander, we've seen the recommendations you also made on the chat box. Thank you very much. We'll be moving on to the question and answer session now. I will quickly post the questions on the chat box. Now, then I'll ask the question to our mentors. Okay. So the first question is, what are the factors that can invalidate a joint operating agreement as
sorry,
regards
so
to
if
the
I go to the
first?
question, I apologize. I have to drop at this moment. But if you have any questions
Okay.
for me, I believe Alexander will be able to take them.
All right. Thank you very much, sir. Okay. I
Thank
also
you.
encourage our mentees on the call to ask live question. We have two mentors with us, Mr. Ayobami and Mr. Alexander. If you have any live question, kindly raise your hand while I call on you to ask your question. I've posted the question on the chat box. So the first question goes to Mr. Alexander. The question on joint operating agreements. What are the factors that can invalidate a joint operating agreement?
Well, thank you very much. Naturally, I would say this question should be better directed to my colleague because he's more into oil and gas. But off the top of my head, like every other agreement, when the agreement, you said invalidate, which is the operative word for me. That invalidate means render null and void, right?
Invalidate, yes.
Yes, render null and void. That's in my own opinion, right? So just like every other agreement, maybe it's not done in line with the law of the land, that can make it null and void. Or so but I think Ayobami will be in a better position to. So Ayobami, please, can you handle this for me? Thank you.
Yes. Sorry. Thanks, Alex. Yes. So yeah, that was the word that you're totally right. Invalidate was the word that I don't know if that's the word you plan to use in asking the question, because invalidate basically, like you said, just means that you signed a contract and it's not even valid, basically. Yes. So, and like you said, yes, if some particular laws are supposed to be followed before a contract, for example, if you don't have a government license and you want to go into oil and gas, or or you don't have a neck license, any contract you have is basically is null and void. Another thing that comes into mind is the capacity, lack of capacity to come into a contract. Now, some parties cannot contract. For example, if you are insane, you can't contract. Some laws will tell you that if someone has had a company has had a criminal records for the last 10 years or something, or someone has had a criminal record for the last 10 years, you can't go into a contract in a particular sector or the other. So there's some sector specific laws like that. Then also, a minor might not be able to go into a contract, especially if he doesn't have a legal guardian, coming in with him on the contract. So those ones are lack of capacity to contract. So it can go in two ways: lack of capacity to contract, and then second way is when the regulation does not allow you to contract because you don't have any rights to contract in the first place. Yes, and this still also goes into mostly of our local content laws. Also comes into in a way or the other. We have in the power, we have in the oil and gas, we have in the maritime sphere. Maritime always goes hand in hand with oil and gas because of the upstream angle of it. Yes, and they have limitations to foreign participation in dealings in Nigeria. So it's quite important that know the limitations to it, know when foreign companies can come into it, when foreign used goods can come into, when foreign personnel can come into it, and that will help you have a good idea of who can contract and if it can be a valid contract or not. Yes. So I think that should answer it, I believe.
All right, thank you very much, Mr. Ayobami, and also Mr. Alexander Akolu, for that answer. The second question, what are the ways of implementing and enforcing regulations in the energy sector?
Okay, so do you want me to start with it?
Yes, Mr. Ayobami can go, and Mr.
Yes.
Alexander will also contribute.
Yeah. So second question, implementing and enforcing regulations. Basically, you need to be on top of your game. Yes. Have people that know the law, know what licenses you should have for a particular operation you're undergoing. And like I said, there are a lot of softwares that help nowadays. Even if you don't have software, some people use Excel. If you are good in using Excel on trackings, But I always rely on softwares because there was a time in my career, I think 2014 and 2015, whereby I had close to 150 licenses I had to keep an eye on. So I mean, it's easy to let anyone slip, through the crack. But I had a Nigerian-made software from young records, and 90 days before it prompts me, and I know that I have to put in a renewal application or a fresh application into it. So it helps to have a tracker. But first, you have to know what you're tracking. That's the first thing. So that means you need to know the regulations governing any particular field you are into it. That will help you. Then also, most companies always have internal auditors that come and sit on the compliance team to ensure that they're up to speed, overshadow or try and find out the evidence. Of course, like Afolabi said earlier, there are agents, there are standards, there's DMV, there's the ISOs, there's TRACE. There are a lot of standards that come and audit you to make sure that regulation-wise you're up to speed and keeps you on the toes, because believe me, it's better those people to come and audit you than you have a government regulator coming and slapping you fines and you losing your licenses and everything. Yeah. So yes. Also on the government angle, the government agencies they usually have deterrents in place of fines and everything, but it's always encouraged. It's always advisable that they try and build not so, we don't like them to be too punitive, in the sense that it's like slamming us with fines and everything. Yeah, but we believe that sometimes they should try and encourage, sensitize, educate, give warnings before the all fine things comes into it. Yeah, but of course they are doing their job, but we just always like when they are not too money conscious. They are more conscious of growth and development of Nigerian-owned companies, basically. Yeah. So I don't know if Alexander has anything to add to it.
Yes, thank you, Ayobami. So this second question has two parts. Implementing, I think implementing is on the side of the licensee or the operator, and enforcing is on the part of the regulatory agency or body, right? So for implementation, the laws have been given by the regulator or the agency, and you need to implement in your local company, either a power sector company or an oil and gas company. So you just have to have people that are knowledgeable in these areas to carry it out. Just as Obama said, you need regulatory guys, you need compliance guys to ensure that every law, every regulation, every order is carried out, and to also ensure that every license, everything that needs to be done because there are even a lot of regulatory agencies that span across these businesses. We have the FIRS, we have the central bank, we have the state agencies. So we might need to get some kind of licenses from them. you need to get you need to be compliant and up to date as with respect to your tax, both to the federal government and even to the state. Further, you also need to even be, I think there's this thing HSC guys say, OSHA compliant, right? That is, you need to be sure that all your health and safety standards are fully up to date, right? So this is for implementation. There are a lot of things that we need to do. So you need people that are very, very sound. And for the mentees on this group, you can decide that you want to be a compliance person. Compliance is something that is very important in these sectors because they are heavily regulated. Fundamentally, without regulation, anything goes. And these two sectors have to be heavily regulated just to ensure that people are not unduly exploited, people are not cheated. For some people, if you leave them, they will sell energy or sell petrol at a very exorbitant prices. So regulations are very, very important. For the enforcement, you need independent regulators, independent regulatory bodies to be able to enforce. One of the reasons why there's no effective enforcement is because some of these agencies are compromised. Without naming names, some of them are compromised, they've collected monies or they've done this or they have, Ibam is smiling, it looks like he has. So I mean, some of them are compromised, so they can't enforce. And that factor is in Nigeria, unfortunately, there's a lot of political interference in our regulatory bodies. So this has affected efficient and effective enforcement of regulations. So imagine when a regulatory agency is saying you need to do this, somebody from the top is saying no, or it's my brother also. So this affects what enforcement of regulations. So these are some of the things. So I think these are my points on just in addition to what Ibami has said. Thank you.
Thank you very much to our both mentors for gently answering the question. I'll be taking the last question while I'm still waiting on our mentees to ask any live question they have. What are the barriers to dispute resolution in the energy industry generally? Mr. Alex can go first.
Okay, thank you. When you say barriers, you're saying what hinders dispute resolution?
Yes.
I would say, you see, in agreement, right? Whether it's a gas supply agreement, gas transportation agreement, the power purchase agreement, investing contract, whatever agreement it is, service level agreement, whatever agreement it is, there is always a bilateral agreement or even what was the last one I just drafted? Supply of last resort agreement. There's always a portion that has to do with dispute resolution. When those provisions, right, are not fully complied with, it is a barrier. Ayobami, okay, Ayobami is on the call. Ayobami, can you help me out here? What are the barriers to dispute resolution?
Yes. Basically, first, you need to know what you want to achieve. You know, which I spoke about it earlier. Falabi, who's also a lawyer, also spoke about it earlier. The fact that we usually don't even know. Everybody's quick to say, "Oh, let's use London Court of International Arbitration." Do you know the rules? We don't know it. The governing law is the laws of England. Do we know the laws? So now, the King George IV, I think, or one of the old medieval lords said, "Woe betide the lawyer that knows all the law." So you're not supposed to. Yes, if you don't know about the laws of England, ask a friend. Have a law firm in England, possibly advise you on that. You know, so we're quick to say that something is Western and we just sign up to it. But we don't have the knowledge of what exactly the rules and the laws entails, basically. Because if you don't know the law, if you don't know the rules, you don't know what you're signing to, basically. And the other party most likely knows what he's signing to, and you know. So for example, even the laws in Nigeria, laws in the common law in England has some various, different variations, basically, now, for example, you can talk about the law of frustration in England, it's a common law principle, yeah, in our contract, it's covered mostly by force majeure, so it's similar, but there's still differences in it. So whatever you are doing, basically, you need to know the law you're signing in. Then, like I and Folabi spoke earlier, the forum shopping is a very important thing. I think a question was asked on it. So forum shopping basically means that the way you go to the supermarket and you want to buy Indomie, and there are various brands of Indomie, and you just feel like, which one do I like the most? You pick the one you like the most. That's how you do forum shopping. Now, when the law the law is not clear and specific, you look for a good example. I think I was hearing something about the news yesterday night about the state the was court. Yes, the federal court. You understand? So the first question that came to my mind was, there should be a federal court in Abia. So that's it. So sometimes people go around actually looking for courts that they think that, or judges they think that has a mindset that they think that they know how the judge would. They do that more in the US, in the sense that the US they use a jury system, and they tend to have a jury consultant that can determine whether a jury would data being used, psychology is being. Forum shopping is just basically means that let me give it on the jurisdiction. The jurisdiction might be where the contract is signed. For example, the office in Abuja, then the jurisdiction might be in Abuja. Typically, there are three jurisdictions by fact. So a party can start a litigation in Abuja and now start in Lagos. And guess what? It's all chaotic already. So that's why it's very important that we have a specific area whereby this is what I want and this is what I want, down to the last letter, down to the I dotting the T. In Nigeria also we have a lot of barriers. Most people prefer foreign when it comes to ADR arbitration. Most people prefer it because we tend not to have a lot of experts in some particular fields in Nigeria. I was once involved in a arbitration in a mediation team, and at a particular courthouse mediation group, and it was an oil and gas mediation, and to get a couple of mediators alone, experts in the field, took quite a long time. So that means we still have some fields that we don't have enough mediators or arbitrators and everything. So as most people prefer to go to the UK, go to Singapore or Hong Kong or the US actually, or France, So that's it. So experience is also, we need more mediators and more ADR experts in Nigeria. And of course, you also have to think about, do you want to go to the ADR system or do you want to go through the court system? Now, some people prefer to frustrate the wheel of justice, and they always prefer the court system because most likely they know that they might have it. They might be the one that will breach the contract. So they know that the court system might be slower than the ADR system. So unlike in England, I spent some time working in a law firm earlier, mid of my career in London, Umar Fenwick, and for example, we had a case, a very landmark case. I was part of the legal team, and it took a while to get to court, maybe like a year, but within a week, the matter was decided, and judges sat every day in the High Court of London, and within a week, it was dispersed. I mean, but in Nigeria, you most likely go for a week, take an adjournment next month before you know, from the initial court to the Supreme Court can take as much as 10 years sometimes. Now the NJC is trying, the Nigerian Judicial Commission is trying to make things move a bit faster, which is commendable. But the fact remains that most people still prefer the ADR system, alternative dispute resolution system, to the litigation system in Nigeria. So all these are barriers we have, in basically when it comes to dispute resolution in energy industry. So it's important that you think about those. The reason why we have dispute resolution clauses in the contract is basically because anything can happen at any time. So most people just feel that, oh, maybe I'm contracting with a sister, a friend that has a complaint, and we'll never fight, but you never know. So you always have to prepare, because anything can go wrong at any particular time. So the most important thing is keep it tight, keep it simple, keep it very clear. Which law am I following? Know the law. Which agency, which ADR mechanism am I going through? Is it the court? Know the rules of that court or the new rules of that ADR, and where do I want it to be placed? Is it in Lagos? Is it in London? Even down to the language. Yes. If you, of course, we are English speaking people, so right, language of the court should be in English. Write it there. All those things. There are generally a lot of contractual formats that you can see, and you see very specific, pretty good specific contract that you can read and just find out that this suits your. Of course, you might also want to include what the parties in, but at least the drafting generally can be used, and for each contract. So it's important that we place very good emphasis and attention to dispute resolution. It's a part that some lawyers just want to skip it. So dispute resolution, this is fine, let's skip it. But no, you need to pay attention to it. Yeah, thank you.
All right, thank you very much, Mr. Ayobami. I don't know if any mentees still have any question regarding the topic before we end the call for today.
I dropped a question on the chat box.
You can kindly read the question.
Okay. The question is actually directed to Mr. Ayobami. During the class, you mentioned forum shopping and PIA. I just noted this. So I would love if you could throw more light to it, sir.
Okay. So forum shopping, yeah. So basically, forum shopping was what I just discussed now. That forum shopping is when you go about shopping for courts, basically to suit what you want. And when the law and dispute resolution mechanism is not so clear enough and gives rooms for multiple courts or multiple ADR mechanisms, it's affected in the sense that each party will look for where that's what forum shopping means. So I know most likely you might not get thoughts about this in undergraduate. Most likely if you're doing your master's in law, most likely it's an area that most likely you would branch, especially when you're into international law. Yes, because forum shopping can actually happen across the borders. Someone starts a proceeding in Nigeria, another person starts in England. It can happen. So what happens if the party in England wins, the party in Nigeria wins? It's a whole lot of chaotic thing. So that's why it's important that you get dispute resolution mechanisms in your contract tightened up. Really important that. And the PIA basically was a law that was 2021. It's supposed to change the landscape of oil and gas industry. Why I'm using the word suppose in the sense that it's still a work in progress. The NNPC has turned NNPC Limited. The DPR is now part of the NUPRC, that's the Nigeria Upstream Regulatory Agency, and you also have the Downstream and Midstream Commission. So there are different agencies now for upstream, different from downstream and midstream. Like we had this fused together. Then also the NNPC Limited is now the one that has most of the operating, even all the operating rights in Nigeria. So basically, down to your JV, NNPC is one that owns. Usually, they used to use the NNPDC as a wheel before the PIA to sign operating agreements with various companies, the Shell, the Chevron, the Mobil, and everything. But now it's more of the NNPC Limited now. So it introduces new laws. I spoke earlier of it tries to address the gas flaring. it is introducing hydrocarbon taxes. There's something they call the frontier 30% for frontier taxes, and and so it's really a lot of regulations. The host communities also they have a host community development of trusts. It's like yes, and basically this which is quite I think 2 weeks ago, and I smiled because it says that for example, if an oil and IOC or a local oil and gas company is operating in it and go truck operations there, technically the host country community will be liable for that. It's a novel new introduction into the Nigeria legal regulation space sphere, and and it's interesting. I think it's quite voluminous. You may want to start pick it up and read it gradually. Yeah, but it's quite important. I'm personally not happy when it comes to the renewable energy. I feel that it wasn't really not much about it. That's what I feel. I feel not much to be done in that space. Like vis-a-vis climate change and greenhouse gas emissions and everything, but than none. So I think with time, Nigeria's 2060 energy transition plan goal, and see how far Nigeria needs over $400 million to thereabout, and let's see how far we can go towards that. Yeah. So I hope I've been able to answer your question, by the way.
Manuel, are you still on the call?
Okay.
Thank you very much, Mr. Ayobami, Mr. Alexander Akolo, for staying with us to the end of the call, and also our mentees that joined the call. Everyone is already leaving. So thank you very much, everyone. Special thanks to our both mentors and other mentors that were on the call today, and also the presenters that present during the presentation. Nice teamwork, and keep up with the good work. With this, we come to the end of the program for today. And thank you, everyone, for joining the call. Bye-bye, everyone. Have a wonderful weekend. All right, bye-bye.
Bye,
Bye, Bye, Alexander. Thanks for joining.
Thank you,
Thank
Julian.
you.